review those records and inform you of whatever criminal history their law enforcement and civilian witnesses have.
So, Your Honor, I think it has a lot to do with like how voluminous it might be.
Right.
And so that and the only other issue I would have is if it is voluminous and we receive it the Friday before trial, then how are we to investigate or address anything that may come up for impeachment purposes that may be contained in that NCIC?
And just to clarify, the two parts. Number one, if this agreed order, we could agree to it, I'm happy just making everything that I have now that is in our possession as of today, making it discoverable today. As far as the civilian witnesses that we have histories for and criminal records for, that way they have a month to investigate it. The only reason I do it on the Friday before is just to ensure if somebody picked up a case in the 31 days between now and the start of trial. That is just to, again, give the defense a fair trial. And I would also like to clarify, we do not run criminal histories on law enforcement officers. Our office has a procedure where we...
Your Brady department?
Yes, we run there. I will have all of my officers run through our Brady division that runs all of the officers, and I will turn over any information that comes back from them. We do not run NCIC, TCICs on all.
Well, regardless of that, regardless of what your Brady department does, I'm ordering the state to turn over any criminal history that any of your law enforcement witnesses have. It's your duty to discover that, whichever way you need to, and turn that over to the defense, regardless of your Brady department.
Well, in your honor, I would direct the court to, and I can get the citation for the court. I believe Ms. West was actually the prosecutor in the court for a case. It's entitled In Ray Watkins. I believe Ms. West was actually ordered to do the same thing, and the Court of Criminal Appeals came back and said that that would cause us to create records that are not in our possession. And I would just direct the court to that.
No, I think there's a difference here. I'm not asking you to create records that are not in your possession. I'm asking you that if there's any criminal history known to you,
Sure.
which you are duty bound to discover,
Absolutely.
that the defense can use to impeach your witnesses, whether they're law enforcement or civilian witnesses, you are to discover those and turn them over to the defense. I'm not asking you to create a document or create discovery. I'm asking you to hand over what exists. Okay.
I of course, will comply with all my obligations under 30.
As you should, yes.
And Brady. I'm not trying to argue that. I just want to make sure that we're clear.
Yes.
If there's anything ever known to us, we would of course turn it over. However,
And anything that you should discover.
sure. I completely agree. with all that.
Proactively.
Just so we're clear, is the court ordering the state to run every single witness through a database?
No, what I'm asking you to do is if there's any law enforcement witness that you have that you're going to call and they have a criminal history
Correct.
or any material information that can be used to impeach them or that's beneficial for the defense, you are to turn that over to the defense.
Correct.
I think my ruling's clear.
Thank you, Your Honor.
All right. Okay, what next?
And that agreed order also, again, contains turning over medical reports, mental health, psychiatric records, just in the process of subpoenaing records. Typically, these will be orders that would be put forth individually. We have just put these together in one small format to not waste paper and have 3 separate orders, and just that we want to disclose all of this to defense and the other parties.
But you're already duty bound to disclose all that. What I'm asking is why do I need to sign a separate order for that?
There are certain things that require, it is our opinion, that the court would have to order us or grant a motion or an order for us to turn things over. Much like grand jury records, they require a particular cause being shown. or particularized need, excuse me, Your Honor.
I'm assuming that's all in the defendant's motions.
Yes, Your Honor.
Yes, Your Honor. So the two statutes we're talking about require orders from the court, similar to as.
Pretrial orders, right?
I'm sorry?
Pretrial orders,
Correct, Your Honor.
correct.
Which is why we're asking the court to sign an order so that we have an order in place.
When I rule on defendant's motions, those items that you're talking about, those issues, they will be covered in those motions,
Sure.
usually.
And
And
Your
I will
Honor,
order the state to turn all that over.
and again.
My
Your Honor,
question again is, why do I need a separate order?
On Monday of this week, when I sent this to defense counsel, Ms. West, Ms. McIntosh, Ms. Evans, Mr. E, I had not received any motions for pretrial regarding either of them, and had not received them up until last night. So
I'll tell you what, let's hold up on that.
that's fine.
Ms. West, go ahead and, well, you already have the defendant's motions, correct?
We have them now, Your Honor.
Okay, go ahead. So y'all review that, and then in an hour's time, we can come back and I'll give my rulings on the defendant's motions.
Thank you, Your Honor.
Okay.
The other, I think, and I don't know whether or not this is going to be out of order, but the other thing was, I believe that our client, Mr. White, Mr. Conway, and Mr. Brown are all set for trial on
The same day,
August 24th.
Yeah.
And so we did want to, and I don't know if the court wants to hear any arguments about that at this time, or if we should do it later.
we can do that now. From talking to the parties, I think after the last pretrial we had, the understanding was that Mr. White's case would proceed first. Has anything changed?
No, Your Honor.
Yes, Your Honor.
What's changed?
And I do want to, if I may, make the record clear. At the time that I think we addressed the order of the trials with the court, Mr. George Ashford was on the case and was prior to Ms. McIntosh, number one. So I want to make sure that that's clear. So I don't believe that the defense indicated a desire for this case to proceed, for Mr. White's case to proceed before any others. But since that time, Mr. Conway has had a very extensive pretrial hearing that had to do with rap lyrics, it had to do with various extraneous allegations, it had to do with other rap artists within the community that are unindicted but being referred to as co-conspirators. But at the center of this case is whether or not there was a payment made to my client by another person. It appears to us that what was raised during his pretrial about the rap lyrics and money being exchanged and various people meeting up or allegations of that his defense counsel undoubtedly will develop a pretty robust defense regarding that.
Regarding rap lyrics and
Regarding the entirety of the allegation of whether or not there was a payment made.
yes, of course, that's the central
That's right,
theme,
John.
right?
Yes. And because Mr. Conway's attorneys undoubtedly are going to develop a robust defense, we believe that there may be information that comes out during Mr. Conway's trial that will directly impact our ability to develop a robust defense. Now, I don't want to misrepresent. We're not suggesting that the state of Texas is withholding evidence as it relates to whatever it is that they may know. But as the court is well aware, Mr. Conway's attorneys have absolutely no duty to disclose anything to the state about what their defense is, or anything to any of the other co-defendant attorneys about what their defense may be. And it may be that the only way that we can discover that there is some alternative theory, that there is some other evidence that exists that would benefit our client in his defense is through that trial, is through Mr. Conway's trial. So as a result, we believe that the only way that Mr. White can really develop a full and fair defense, and that we have our duty to protect his constitutional rights and all of that kind of stuff. The only way that we can do that is if Mr. Conway's case is able to proceed forward, and that we can glean any beneficial evidence through that trial in favor of Mr. White.
And if I may add, as the court knows, remuneration and shooting is two of the major elements here. Remuneration, there may be financial records that Mr. Conway and his attorneys are in possession of that they don't have a duty and obligation to share with anyone, not even to the state or the court prior to the court proceeding. If that is entered into evidence after Mr. White goes to trial, then he would be at a disadvantage. And it would be unfair justice for Mr. White because we weren't privy to that information. And if Mr. Conway, if that evidence leans a not guilty or whatever, then the information that the state has given could be misleading. And at this point, we're asking that the case as it relates to remuneration goes first, because they might have more evidence that we don't have.
Okay, what's the state's response?
Multiple things, Your Honor, if I may. Going back to our conversations in January when we were set for the first week of February, I had made it known to this court that my intentions and our plan was to go on Q1Y. That was who we wanted to go to. He is the alleged shooter. And at that time, if the court will remember, we had an extensive conversation in chambers that Ms. McIntosh would be brought onto the case. I know she wasn't in the courtroom that day, but she was being brought on the case. You had appointed her as well. And the understanding, and I know we all love Mr. Ashford and wish he was here, but even at that time, the court was full aware of the situation that was going on there. And in chambers, you made it very clear to us in Ms. West that everybody would be ready for trial on August 24th, and you knew our position at that time. All of these defendants have been indicted for capital murder since March of 2025. Mr. White has been indicted for murder since January of 2021. Ms. West represented him in the Northern District of Texas, and then was brought on with Mr. Ashford in 2021.
Right, I remember that conversation, and Ms. White has, Ms. West had access to a lot of discovery.
The majority of it.
Majority of it, yes, back then, even before.
Correct.
Yeah.
And Your Honor, at that time, if the court will remember, even prior to Mr. White being brought back, because if you remember, we brought him back on a writ of ad prosequendum from the federal government. And we had to have a hearing before you, and you signed off on that order. We had to get a trial date, and we made representations to the Bureau of Prisons and the federal government that we would be ready to go to trial on it first. And even then, once the court did it, Ms. West appropriately lodged her objections for multiple reasons, but brought up her fear and concern and safety of Mr. White being here in Dallas County Jail, and made it a big part of the record as far as his safety, and there's hits out for him, and that she wanted him to be housed at another location. And the court said, no, he'll be housed here. And so he came back and he's been here. And so at that point, we know now that he's in single cell. He has to be escorted by SRT. And so, Your Honor, part of that is disingenuous to now say, well, he's here. We want to even, I'm willing to put his safety at risk, I guess. And the jail is having to deal with him being in single cell. You know from prior hearings that he's going on YouTube Live and talking about evidence and discussing grand jury records and grand jury testimony. We've come before you and discussed that. Further, Your Honor, I don't understand, maybe I should, that all of this evidence that has been provided to defense counsel, nothing has come out as far as rap or anything like that. The murder for remuneration has been the indictment since March of last year. Whatever Conway's attorneys do is what they do. I don't understand the idea of I get to sit back and see what goes on with their case to see how it might benefit my client. Defendant has been in custody since December 9th of 2020. I have a family that's sitting here that deserves justice. He was indicted in January 2021 for killing Melvin Noble. Yes, we enhanced the charges to capital murder last year. But based off of everything procedurally that has gone on with this case, and the fact that he is on loan from the federal government, that this court had to sign an order, and every single time we've had a setting, it's been another reason why this family cannot get justice. Whether they want to sit back and see what, I'm sure Mr. Conway, they're probably going to say they want to go first. I understand that. He's on bond. Wouldn't every co-defendant want to see if they can benefit from their co-defendant's trial because something else might come up that's good for them? Nothing new came off that stand as far as evidence that we are planning to admit. In Your Honor, we are asking the court to do what's right, not only by the criminal justice system, but by the family, and let this community hear this case of the man who's alleged of shooting and killing Melvin Noble on I-35 and is also charged with aggravated assault for shooting a neurosurgeon in the head that day on the freeway.
Thank you.
May we respond, Your Honor?
Yes, go ahead.
Thank you. And just so the record is clear, it's my understanding that the only case that's moving forward to trial in terms of guilt innocence is the capital murder. So I appreciate the state saying that there are other allegations that are pending, but the only case that I've been told we're going to trial on is the capital murder charge. Furthermore, everything that Mr. Adams just talked about has nothing to do with the evidence in the case, which is what we're dealing with, and that's what speaks directly to Mr. White's ability to have a fair trial. The reality of the situation is the only evidence that the state of Texas can provide to us is the evidence that they have. That doesn't have anything to do with any evidence that may come out during Mr. Conway's trial that is identified by his own attorneys.
I mean, the same could be said for any of the co-defendants.
Well,
I mean, if I gave you all the choices to who wants to go first, I don't think anybody would want to go first.
Well, I think that if you were to talk to some of the lawyers, there are some that want to go first. I do think that. And so I think that in this particular case, what Ms. McIntosh and I are trying to do is ensure that our client has a right, that we're starting at the same starting point, right? And I think that would include being able to get information that nobody has to know until trial as it relates to Mr. Conway.
Your client is the alleged shooter, correct?
Yes, Your Honor.
Your Honor, if I may,
Yes.
this case is different than most capital murders that the court may have seen in the fact that this is dealing with remuneration. And in the state's indictment, it says specifically that Marquise Conway paid Keyone White for remuneration. That means, and I'm a finance and accounting major, Your Honor, previously and worked in finance and accounting. I know that there may be documents, there may be bank statements that the state is unaware that they might not know. And that may be provided or introduced in trial that from Marquise Conway's attorneys. And if we go first, Keyone White is at this point. This has nothing to do with how long he's been in jail. He could be in jail for, I'm sure Mr. White, if he was to testify right now, would say, I want to make sure I have all that evidence before I proceed to trial, and I'm going to wait prior to we're just going off of what the state has and what the state is alleging. Because that, I believe, could put Mr. White in a strong disadvantage. It is unfairly prejudiced him if we don't have all the information that Mr. Conway may have. And the only way we get that is if Mr. Conway goes first.
Your Honor, may I please respond?
Go ahead.
There has to be some correction here. First of all, I want to direct the court's attention that on July 14th, I was asked by Ms. West, actually I was asked on the 6th, Ms. West has a trial set on the 10th of August in the 283rd. Her and I had a conversation. She made representations that she knew that we were going first. And I believe she even put that on the record in the 283rd to get that case taken off the docket and get a continuance. And she can shake her head no in this courtroom, but we can get the record that she understood and knew that we wanted to go on her client first. That is not even up for a question, or I want to make sure that is very clear. She's made representations to other prosecutors in this office and another judge. Secondly, as far as documents,
allow him to finish.
Okay.
as far as documents that Mr. Conway may or may not have, they can subpoena records as well. Mr. White has been in custody since December 9th of 2020. He's been indicted for capital murder for a year and a half. They've had the opportunity to subpoena any and all records and also as a finance major and having an MBA, yeah, there could be more records out there, and they can go and seek those out. That's an obligation on them to their client. And finally, as far as Ms. McIntosh saying that if you were to testify right now, that he would say that he would want to wait. I've listened to him on YouTube a whole bunch saying, I'm not going to trial. I'm not going to trial in August of this year. He doesn't want to go to trial. This is a game, Your Honor. It's a delay tactic and a game.
All right.
And I'm so sorry.
This is the
Your
last thing I'm going
Yes,
to hear about this.
Of course,
Go
I
ahead.
apologize. It's just that Mr. Adams put on the record suggesting I may have made misrepresentations to other members of the DA's office and to another judge. So I have to correct that. What I told, this case is set for August 24th. I have another case that was set August 10th. At the time that I was asking for that other case to be reset, this court hadn't made a decision about which case was going. And so what I did represent is that I knew that Mr. Adams wanted to go forward on our case, which I did know. That had nothing to do with anything that came up after that, but it also had nothing to do with the fact that if I was in trial on a first-degree felony 2 weeks before this Capitol River case that has 20 terabytes of discovery, then I'm putting both of my clients at a disadvantage. So that is what I put on the record, and I can get that record from that other court should it
Okay.
become necessary. Because
There'll be no
don't want
need
it-
for that. There'll be no need for that.
If I may, this is, I'm highly disturbed because this is not a civil case. We don't know any information about Mr. Conway's records except what the state has provided. And we can't do depositions, we can't talk to Mr. Conway ourselves. So to say or even suggest that we could subpoena records that we don't even know exist, or whose name, what name, if he shares a bank account, what other information is going on, I think it's disingenuous. At the end of the day, if we don't know what records Mr. Conway is introducing or admitting into trial after the fact of Mr. White, he is prejudiced. It is probative that we have all the financial records and documents that is going to be introduced into Mr. Conway's trial. And as the prosecutor sits there today, he cannot say unequivocally that he knows all the evidence that Mr. Conway from his financial records is going to introduce into trial.
Okay. Now, you all are making all these arguments, but I've been an integral part of these discussions about what case is going first, the continuances, the reasons behind them, the discussions that we had in chambers regarding what cases moving forward. And so based on all that, Kewan White's case will go to trial first. So everybody be ready on Kewan White. So I'm going to give you all an hour to review the defendant's, Mr. White's motions. And let's reconvene at 11 o'clock. Okay? Is there anything else before we do that?
And we'll take up the other councils at that time as well.
Okay, Mr. Shook, did you have anything you wanted to say on the record? And this is
Judge,
Kewan White on the record at this point. So this is counsel for co-defendants speaking. Go ahead.
Judge, on behalf of Mr. Conway Williams, we are ready for trial and would like to go to trial.
Yes, I asked everybody, all of you to be ready. All the co-defendants shall be ready on that day in case something happens. Because, as you all know, sometimes parties work out a deal and fall off, and then the next person would have to come up. So everybody be ready. So you're announcing ready?
Yes, sir. Yes, sir.
And Mr. Harris. Mr. Harris
Yes, ma'am.
and Delane Evans?
Yes,
Okay, and you all will be ready on the 24th as well, correct?
we're ready.
Okay,
Same ready, Judge.
okay, very good. All right, let's, we're off the record.
Just one line. I
Okay,
just said that to be able to.
okay, off the record. Go ahead.
I did want to ask on the record at some point, a couple of statements regarding the matter we brought up with our last pretrial with Mr. Adams.
Okay, I'll have to call up your case for that.
Do you want me to, do you want us to come back at 11 after you're done with that?
No, we shouldn't. Let's go ahead and handle that now.
Okay.
Yeah, Mr. White can go. All right, we're on the record. This is cause number, where is Mr. Conway? He would step forward. All right, this is cause number F2500154, State of Texas versus Marquise Conway. Is that your name? Let the attorneys announce their presence.
Cody Shook for the defense.
John Bishop with defense.
Ricardo Bell for the state of Texas.
Tommy Adams, State of Texas.
Thank you. And Mr. Shook, you had certain things you wanted to put on the record today?
Yes, Your Honor. At our last pretrial hearing, we have requested, filed our motion about revealing any deals or benefits given to any of the witnesses that was testifying for the state. Mr. Adams had stated on the record that he had made no promises or benefits from the state, but could not state on the record that what the federal prosecutors had done. And I believe at that time you said, well, ask them to use due diligence to make inquiries into that. So I wanted to follow up on that aspect to see if there were had been any other, if he has new information regarding that, so we have a record of that. That's one of the issues.
Okay. So any updates by the state?
Yes, Sean. I actually sent defense an email yesterday, and I sent them one last week as well. As far as certain documents that are currently in, again, Your Honor, if there's any information that comes forward that deals were made either on my behalf, the state's behalf, of course, we would inform defense immediately. Nothing has changed as far as that is concerned. We have not made deals or cut any type of deals, made any promises with anybody as far as the state is concerned. However, Your Honor, as I brought up last time, we can't control the federal government and what they turn over and what they don't. I made a request earlier this year and have continued to follow up with federal prosecutors regarding that information. I did send defense an email yesterday at 2:12 p.m. Regarding some of the information that they were, I believe that they're looking for. However, it did take a while because the federal prosecutors needed permission from the federal judge to release it. And so I forwarded that email to defense counsel as far as yesterday afternoon, and it lists the things that are available for them. And in fact, it lets them know that they can come by, but they will need to coordinate. And they can review it there at their office. They're not going to release those documents to us. Defense would have to coordinate with those federal prosecutors to go over and make a time to go review that information.
Okay. Mr. Shook, is that the information you received?
Yes, Your Honor, we did receive that email.
Okay.
The other issue, Judge, we talked with Mr. Adams on several occasions. He's indicated, as the court knows, there is a large amount of discovery in this case, some 16 terabytes. Mr. Adams has told us that he would meet with us and show us the exhibits and evidence that he planned on calling his case in chief. We have not mentioned that on the record. I just want that agreement by Mr. Adams put on the record so there is a record of it.
Okay. That the state will prepare an exhibit list?
Well, that he will show us the exhibits he plans on using in his case in chief and go over the pieces of evidence, witnesses that he plans on calling.
Okay, and the court will require an exhibit list as well.
Absolutely, Your Honor. And just as I did last week for our hearing, I'm going to provide everybody with an exhibit list. And just as I did as far as this last hearing, I sent all of those exhibits to defense counsel via text share so they could see. Now, of course, I'm going to, and I've started preparing those exhibits for the trial. I was working on that yesterday. Those will be uploaded as well for all of the attorneys. This doesn't just apply to Mr. Conway. I'm doing this for all of the defendants, so that everybody can be on the same page as far as the exhibits we intend on offering. These are intended exhibits.
Right.
There could be deviation, and this is not a smoke and mirrors or trying to trick anybody, but if the court will remember even from last week, I had a whole long list of exhibits, and there were some that I didn't put in, and then there was one that I had to add. I'm planning to give them as much as I can to show them the exhibits that we plan on it offering. Of course, we filed notice of intent to use business records. That's a good indication. However, I'm going to continue as we get closer to August 24th to provide them with, these are the photos, these are the videos, and I will give them the evidence list that I will have here for the court and the court reporter as well, just to make this thing smooth and as streamlined as possible.
Right. I appreciate that.
Yes, Ron.
Anything else?
I believe the court has us scheduled for, the trial date's August 24th, but there's no pretrial date set for August 21st.
Well, yeah, if necessary, the parties can convene on that day. If there's anything else that comes up, I think we just scheduled that just in case.
As a check-in.
Right.
And Your Honor, if the court would remember, we did appear earlier this year, and we had discussions regarding these motions. We never got into the substance of the omnibus pretrial motions, and I don't know how this happened, but an omnibus motion that had checks of certain
Right.
things had made it.
We discussed that, yes.
Correct.
That was a different, yes.
And the court had actually made a
Docket entry.
docket entry that we would take up. It was entered in error on the 9th.
Right.
Okay, so we still need to take up this, Mr. Conway's omnibus motions. I believe ours have all been ruled on.
Okay. Now, Mr. Shook, do you all intend to present that motion or not?
Yes, I think we've come to agreements on most of them. But we'll have to discuss that again.
Okay, y'all talk about that in an hour. We'll talk about both, okay?
Thank you, Your Honor.
All right.
Thank you, Judge.
Off the record.
Thank you.
Thank you.
Joe, are we excused?
Yes, for now, for the next hour.
You guys come in there. Your Honor, would it be possible for us to use the jury room just for us briefly to tell them what?
That's fine.
Thank you, Judge.
About 11 o'clock. Yeah, I'm gonna say,
That's gonna be you would have to see how long you would anticipate with it.
Then you just got that.
Yeah, it's all telling you, right? It's not really, I'm saying it's out of. I'm not sure.
If you just need to vote later, so,
It's all there. We're all there. They don't do it. Like, People like this thing. Thank you.
You can go on that side for you.
All right, so they got an hour recess. You know what I'm saying? They come, we'll be back on whenever they come back on. That's for sure. You know what I'm saying? This trial gonna hit the fan, man. I'm telling y'all, they finna hide them. They finna hide them. They lawyers. I'm just saying, man. They. I couldn't go to trial with no lawyers like that because of how they was responding to the judge. You know what I'm saying? Like, you got to be on point. You got to know what the fuck you talking about. Code number, whatever. You got to know all that shit. That's your job. You know, that's all Coffee gonna say on that. But I appreciate the love, Buck. I appreciate you. You know what I'm saying? Everybody that helped donate to the channel, I appreciate y'all, man. I'll be back.